Good evening, sir.
वेरी
Good
वेरी
evening,
गुड
sir.
इवनिंग अभिषेक, हम लोग आपको दिखाई और सुनाई पड़ रहे हैं. वी आर ऑडिबल एंड विजिबल टू यू.
Yes, sir. Yes, sir.
तो कुछ अपने बारे में बताएं, अपना परिचय दें.
Sir, I belong to Patna, Bihar.
हाँ.
I have pursued my BB LLB honors from Chanakya National Law University, Patna, and this is my very first attempt for Bihar Judicial Services.
When did you complete your PLLB?
So I have completed my BB LLB honors in 2022.
2020. So Chanakya, what do you know about this great man of India?
Sir Chanakya, also known as Kautilya, and his original name was Vishnugupt. He was the teacher or mentor of the King Chandragupta Maurya I, and Mauryan Empire flourished in his guidance.
So what was the extent of Mauryan Empire?
Sir, the extent of Mauryan Empire was from India and also it reaches to Afghanistan and Pakistan.
And the principal seat of Mauryan Empire was?
Pardon, sir?
The principal seat of Mauryan Empire was at which place?
Sorry, sir,
The
I didn't
kingdom of Mauryan
understand.
Empire.
Kingdom of Mauryan Empire. Sir, Patna was the capital of for Maurya Empire.
No such city was in existence at that time. In this
Patliputra, sir.
part
The
of
original
part.
Patliputra.
part.
Yes.
Okay. So, what are your optional subjects?
So my optional subjects are commercial law, constitutional and administrative law, and torts and contracts.
So, in the constitutional law, there is a provision of uniform civil code.
Yes, sir.
Which state in India is going to implement uniform civil code shortly?
So Uttarakhand became the first state to implement UCC.
Prior to that, there was no state in India.
Prior to that, sir, Goa.
So, how come when Goa implemented uniform civil code?
Sir, it was under the control of Portuguese. So,
So, the old colonial Portuguese law is in existence.
yes, sir.
Do you agree that India should adopt a uniform civil code, or there must be different personal laws for different communities?
Sir, Uniform Civil Code, as it is the common civil code, it would be beneficiary for the society. But in my point of view, time has yet not came to implement UCC in its full-fledged form.
When the time will
As the
come, why it is not a right time?
Sir, because the second Muslim majority people, which is considered as the largest minority in India, they are against it because they have different civil laws for succession, marriage, and inheritance. So all laws would be affected with that.
So, in
So
future, when do you feel that Muslims would readily agree to this?
yes, sir, time is not certain, but
When that time will come, when Muslims will offer themselves happily that now we are able and ready to adopt Uniform Civil Code, Government of India should and must execute it.
sir, I think there should be uh, advertisement for this UCC law and awareness program should be conducted. So the people, the Muslims which are against it, should be aware of the facts that the uniform civil code would be beneficial to them
Okay.
also, as it would be a
Recently,
common
Supreme
civil
Court.
code.
Okay. Recently, Supreme Court announced a judgment related to Citizenship of India Act. So, which is the
Yes.
section and what is the judgment?
So Section 6A of the Citizenship Act in Assam, the problem was that the Rohingya Muslims from Bangladesh, they are they are getting the citizenship under this section.
Okay. when the company law was changed for the last time and what were the recent provisions introduced in that law?
Sir, companies law was amended in 2013, and the laws related to that
After
was
2013, no changes have been made.
in 2018 also there was minute amendments, but the major amendment came in the 2013.
What were the provisions introduced in that
Sir,
Companies
in
Act, which were not present
2018,
to 2013?
2013, sir, the provision of one person company was introduced, and
And
sorry, sir, I'm not able to recall any more points.
अभिषेक, आपने अपना
Yes,
ऑप्शनल पेपर जो है वो टॉट भी बताया, ठीक है?
yes, sir.
इज इट टॉट और टॉट्स?
Sir, there are two theories for that. The pigeonhole theory, which was propounded by Salmond, he says that it is law of torts. But the theory given by Winfield, it declares that it is law of tort. But what we study in our law school is law of torts,
तो
which is
आपके
given by
हिसाब से क्या
Salmond.
सही है, टॉट्स सही है या टॉट? इनफील्ड की थ्योरी सही है, सालमंड की थ्योरी सही है?
Sir, if we move through a narrow approach, then Salmond theory is good. But on a greater aspect, or when we see a common injury to all, then Winfield law of tort is better.
क्या आप ये कह सकते हैं कि सालमंड की थ्योरी जो है उसको गलत साबित कर रहे हैं विनफील्ड? कुछ ऐसे एग्जांपल्स दे सकते हैं जिन एग्जांपल्स से ये साबित हो रहा है कि पिजन होल थ्योरी जो थी वो सही नहीं है और
Yes,
जो
sir.
विनफील्ड के द्वारा दिया गया स्टेटमेंट था वो सही है?
Yes, sir. Sir, in pigeonhole theory, there are specified number of torts, but after the passage of time, there could be more harm, more damages which could occur, which Salmon have not mentioned in the in his definition, law of torts, because there are specified number of torts. But Winfield cover every aspect of injuries, every aspect of legal injuries for which there is a remedy provided.
नहीं, तो आप कैसे, कोई एक एग्जांपल बताइए जिस एग्जांपल से आप ये क्लियर कर सकते हैं कि सालमंड की थ्योरी बेहतर नहीं है?
Okay, sir. Sir, like a tort of nervous shock, it recently emerged. But when Salman was alive, then this tort was not in existence.
और एग्जांपल दीजिए।
A tort of medical negligence
नेग्लिजेंस
and
तो था शुरुआत से।
medical
एब्सोल्यूट
negligence,
लायबिलिटी,
medical
एब्सोल्यूट
negligence.
स्ट्रिक्ट लायबिलिटी की जगह पे अगर हम बात करें, एब्सोल्यूट
Yes,
लायबिलिटी जो था, एब्सोल्यूट लायबिलिटी
yes,
को डेवलप किया
absolutely.
गया। हाँ, एमसी
Yes,
मेहता का केस था।
yes, sir, MC Mehta.
नेग्लिजेंस की आपने बात की, नेग्लिजेंस में एक चीज देखते हैं, कॉन्ट्रीब्यूटरी नेग्लिजेंस क्या होता है ये?
Yes. So when plaintiff and defendant both contributed into the act which suffers the harms by plaintiff, then this is contributory negligence. When both contributed in the act and plaintiff suffered due to which, it is contributory negligence.
क्या रेमेडी मिलेंगी इसमें जिस पर्सन को कोई इंजरी होती, किस हिसाब से? क्योंकि दोनों तरफ से अगर हम बात करें कि नेग्लिजेंस था, तो रेमेडीज जो होंगी, रेमेडीज किस हिसाब से प्रोवाइड की जाएंगी और क्या इसके कुछ एक्सेप्शन?
Yes, sir. So, in case of contributory negligence, we generally see that on part of whom the injury or the act could be avoided. So, the if it could be avoided by that person, then that person would be liable more than that person,
इसी
than
में
the other party.
लास्ट अपॉर्चुनिटी रूल या लास्ट अपॉर्चुनिटी थ्योरी भी अप्लाई हो,
Yes,
जानते
sir.
हैं इसके बारे में क्या है?
Yes, sir. Last opportunity rule. What I just said that was last opportunity rule, sir.
हम्म?
So what I just said that was last opportunity rule. That
इसके पास में
the
लास्ट तक अपॉर्चुनिटी रहती, ठीक
the
है।
last person which could avoided that injury.
अभिषेक, आपका फेवरेट सब्जेक्ट कौन सा है?
So although I have read all the subjects, but my inclination is more towards law of evidence.
लॉ ऑफ एविडेंस। व्हाट इज डिफरेंस बिटवीन एविडेंस एंड प्रूफ?
So, evidence as defined under the Section 3 of the Indian Evidence Act, it means that a statement which could be oral or written, which could be produced for the inspection of the court, is known as evidence. But it is proved or not, that is given under Section 4 of the Evidence Act, that it is proved or disproved. So, by adducing the evidence, a fact is proved, a fact in issue is proved.
एक इंडियन एविडेंस एक्ट में ये कहा जाता है कि ऑल रेलिवेंट फैक्ट्स आर नॉट एडमिसिबल, ऑल रेलिवेंट फैक्ट्स आर नॉट एडमिसिबल बट ऑल एडमिसिबल फैक्ट्स आर रेलिवेंट फैक्ट। आप
Yes,
कैसे
sir.
इस बात को प्रूव कर सकते हैं? कौन कौन से प्रोविजंस का सहारा ले सकते हैं जिससे इस स्टेटमेंट को सपोर्ट किया जा सके?
Yes, sir. There are certain number of provisions, such as Section 25 of the Indian Evidence Act, which clearly states that confession to the police officer is, sorry, sir, a statement to the police officer is relevant, but it is not
नहीं,
admissible.
सही बोल रहे थे, कन्फेशन
Sorry,
सही बोल रहे थे। हाँ,
confession to the police officer is relevant, but it is not admissible.
हाँ,
The second ground would be privileged communications, which we can see in sections 122 and 126 of the Indian Evidence Act. And also, sir, Supreme Court ruled in the case of Ram Bihari versus State of Bihar that relevancy and admissibility are not synonymous terms and not coextensive also.
पढ़िए।
अभिषेक,
Yes,
आप पटना में रह रहे हैं,
yes, sir.
आपके ऊपर मतलब इंटरव्यू का प्रेशर है? आर यू टेंस्ड? आर यू फीलिंग प्रेशर?
Sir, I am feeling little bit nervous, but not much.
चेहरे से आपके लग रहा है, तो थोड़ा सा स्माइल। पूरे इस कन्वर्सेशन में आप 2 ही बार मुस्कुराए हैं, है ना? थोड़ा
Yes,
सा चेहरे पर आप अपने मुस्कुराहट रखते हुए जवाब दीजिए, ठीक है? तो my
sure.
first question to you is that recently a yatra has been introduced in your Bihar known as Hindu Swabhiman Yatra.
Yes, sir.
Could you please tell me what is the origin and the last point of this yatra? From where this yatra originated and where it is going to culminate?
So sorry, sir, I don't know the exact places, but I knew some of the facts about this.
What facts?
Sir, like BJP MP 𝗀𝗲𝗄𝗏 Singh is going to conduct the Shobha Yatra, and
Not going to conduct, already conducted.
already conducted. He is now in Araria and Kishanganj today, and his statement was very controversial that if any person has to live in Araria, uh, he has to change his religion to Hindu religion.
Okay. Okay, do you believe in the slogan given by the CM of Uttar Pradesh, "Batoge to katoge"?
Pardon, sir?
My question to you is that do you believe in the slogan given by CM of Uttar Pradesh, Yogi Adityanath, "Batoge to katoge"?
No, sir, I do not agree.
You don't agree.
Yes, sir.
But the excellent example is Bangladesh.
Yes, sir.
Then
I agree to that point also. Sir, but our country is not Bangladesh. Our country is treated as a federal country after America, and it secularism is a basic feature of the Constitution of India. As India has no religion of its own, so we have to treat all religions equally.
but number of times PIL has been filed in the Supreme Court and number of times it has been questioned in the parliament that the main villain to Indian fabric is the word secularism in the preamble. Don't you
Yes.
think so that this word should be removed from preamble? Highly misused word of Indian constitution is secularism.
Yes, sir, I agree to you with a certain extent because secularism was not not included in the original constitution. It came via amendment, 42nd Amendment, 1976. It was added in the preamble then and that only. And to include it in basic structure of the constitution, we can say that time is not certain to justify this.
Okay.
Abhishek, you have answered most of the questions satisfactorily well. Your body language is very good. Your communication skills are appropriate. And we all feel, wish, and bless you to qualify this examination. All our good wishes and blessings.
Thank you, sir. Thank you, sir. Thank you, sir.